I'd like to warmly welcome everybody present here today. This is the first Young Lecture series which has been organized by this particular core, and we are privileged to have with us Mr. Anirudh Hariani, Independent Counsel at the Chambers of Mr. Mustafa Doctor, and he is an alumnus of Government Law College and has completed his LLM from Cornell Law School, and we are privileged to have him with us.
I must thank the Alumni Association, Anushka, Sachi, everyone for having me today. It's my honor to be here. And it's a very big privilege to come and speak to students on something which you wish that someone had spoken to you about when you were in law school. Now, today, what I want to talk to you about is a career in counsel practice because that is what I do. And I'm sure that many of you have questions on how exactly to go about it, what it involves, etc., etc. When Sachi had first gotten in touch with me, she had suggested some other topics on law. I had also thought of various topics in environmental law, maybe IPR, arbitration, or even litigation strategy, because these are some of the topics which interest me. But then what I thought was that this would be a little too dry for our session today. And since we're talking to students, I thought something which is directly relevant to you, that is your career, would be far more important and interesting for you. So, what I intend to do is have a question and answer format where I'm going to ask very common questions on counsel practice, my experience in it, and I'll answer those questions. And these are questions which I really wish I knew the answer to when I was in law school in GLC. And then I'll speak for about half an hour on that. And then thereafter, we'll keep it open for questions. I'm sure you all may have some questions which you may want to ask me about counsel practice, etc. So you can please switch on your videos and ask me, or you can type it into the chat and you can ask me there as well. And I'll be happy to answer those questions. Before I go into the questions, the questions that I will ask myself, I want to give you a brief background about what I do and how my career has come to where it is today. I was, as you know, an alumnus of GLC, and during law school, I interned at various places, as you do. And I also interned, one of the places that really interested me was interning in the High Court. So I interned with Mr. Darius Khambata, who's the leading senior counsel today, and also with various other counsel and even a judge, Justice Wazifdar, who was later elevated to the Chief Justice of the Punjab and Haryana High Court. And these experiences really gave me a flavor of what it's like to be in litigation, to appear in court. I experienced the thrill vicariously through these uh, eminent jurists of appearing in court, of standing on your legs, of delivering for your client when it matters most. And that's what really interested me while I was in law school, though, of course, I did internships in corporate law, etc. Immediately after graduating from GLC in 2011, I went for my LLM to Cornell Law School, and I did a variety of subjects, including international commercial arbitration, negotiation, and things like that, which come into use today in my experience as a counselor. And what I also did was various workshops. I interned with various uh, organizations. I got a flavor of litigation. Soon after that, I came back to India and I started working with a law firm. And initially, I did everything. I just didn't stick to only litigation. I did litigation, I did corporate transactions, I did a bit of property law. And slowly, I got more and more attracted to litigation. I didn't decide right away that I was going to do counsel practice. No, that's not how it went. But I always had that in the back of my mind. And in the meantime, I had signed my articles. So I gave my solicitor's exam. I was lucky to clear in my first attempt. And eventually, for about 4 or 5 years, I worked with the firm. And then I decided that, if I don't make the shift right now to counsel practice, which is something that I'm really interested in doing, then it won't happen at all. So, about 4.5, 5 years ago, I made the switch, I took the plunge, and now I practice civil and commercial litigation and also arbitration at the Bombay High Court and in the chambers of Senior Counsel, Mr. Mustafa Doctor. So that's a brief background about what I do and how I got there. But now let me answer a few common questions about counsel practice and what it is. So the first question, of course, is what is counsel practice? And counsel practice really is the purest form of practicing law. In essence, you are appearing on your legs before a judge or before a tribunal or an arbitrator, and you are arguing the case for your client. Now, typically, this involves thinking on your feet, it involves a lot of preparation. And the difference between a counsel and an advocate who is instructing a counsel or an advocate on record is that a counsel generally, especially on the original side in the Bombay High Court, does not file his own wakalatnama. The client, his client, the counsel's client is the law firm or the advocate on record or the solicitor, whatever name you want to call them. And thereafter, the solicitor or the advocate on record's client is the actual client. So you're an agent of the solicitor or an agent of the client in essence. You don't handhold the client, you don't file your own wakalatnama, your name is not the advocate on record. Previously, as we know, there was a dual system of solicitors and barristers in India based on the British system. And barristers are what we call counsel today in India. And they were the ones who had the right of audience in higher courts. Solicitors did not. Then in about the 70s or 80s, this dual system of solicitors and counsel was abolished. And now everyone is an advocate under the Advocates Act 1961. Still, there's a distinction in many high courts, such as the Bombay High Court, in Chennai, in Calcutta, of having a separate advocate on record and a counsel separate. And the reasoning is that the counsel can focus on the arguments and the advocate on record can focus on the client and meeting their needs. So this is essentially what a counsel does. He is, you can think of him as a hired gun or an agent of the solicitor himself. Now, a solicitor is also a very important cog in the litigation wheel. The solicitor will do the filing, will handle the client, will really get into the crux of the situation to brief the counsel. And solicitors, as you know, are very knowledgeable. They also, you have to take a very difficult exam in Bombay under the aegis of the Bombay Incorporated Law Society. So it is another aspect of litigation, but today we're talking about counsel practice. Now, a very important aspect about counsel practice, at least on the original side of the Bombay High Court, and what I mean by original side is where the original... Thank you. So the original side of the Bombay High Court is where the original jurisdiction for filing suits, civil litigation is. And so therefore, when we say original side, there's an appellate side where appeals from lower courts are heard, and there's an original side which is the trial court or the court of the first instance in this case. So the original side of the Bombay High Court has a very peculiar system where, as I mentioned, counsel don't file their own wakalatnama. Also, your senior will not pay you a salary. So what this means is that you get your own briefs from law firms, from advocates on record, and your senior does not pay you anything, you're not an employee of your senior. And this is a very, very important distinction, because in many places, and even on the appellate side of the Bombay High Court, the senior will pay their juniors to a salary, maybe a stipend or a salary, and they effectively become an employee of their seniors. But this is not the case with counsel practice on the original side. And it is both an advantage and a disadvantage. So, really, the second question, this is counsel practice, and if you have any questions on it, we can answer it later. But the question is it for you? Is it for everyone? And the simple answer to that is it's not for everyone. It depends on each person to person whether they look at it in a way which they can strive, they can benefit in, or whether they look at it as a pain in the neck to appear before the High Court, to appear before a court, and the like. So, if you enjoy working under immense pressure, or you don't mind working under immense pressure, if you don't mind standing on your feet and having to think on your feet and appearing before a judge, then this may be for you. But don't think that it doesn't involve a lot of hard work. You have to get into detail on the facts and on the law, because ultimately it is your neck on the line. You're the one who's appearing before the court, you're the one who is giving the submissions, and if you give a wrong submission, then you're the one who is going to be caught out by the judge and your reputation will be affected. A common question that I get is public speaking a prerequisite? Are you supposed to be good at public speaking to be able to be a counsel? And the answer to that is yes, but it can be honed over a period of time. So it's not like any senior counsel, for example, Mr. Janak Dwarkadas started off as a great orator. In fact, he has said in many talks and speeches that he has given that he was a very, shy student, and he did not enjoy speaking in public. So it can be honed, it can be really, you can get good at it, you can develop that skill. Again, another big misconception is that you need to be good at, you need to be aggressive or loud. And that is also a very big misconception. You don't need to be aggressive. In fact, I've seen a lot of the seniors in the High Court and even my contemporaries who are soft spoken but who get the point across. They are assertive. They need not be aggressive and loud. So that's also something that you don't need. But one thing that you do need, at least initially as a junior, and this is more what you need when you're starting off, is to be able to be pleasing to the judge, in the sense that you want to get your point across without really arguing, or without arguing with the judge too much. And so that's a matter of demeanor, that's a matter of advocacy which you learn over time. And the other thing that I would say for juniors that is very important is you need to be friendly, you need to network, you need to build your contacts, because ultimately your contacts in the industry, in law firms, in advocates on record, they are the ones who are going to be briefing you in matters. And so you need to develop that skill of being friendly and being sincere, genuinely friendly with people, interested in what they are talking about, and that's how you will build your practice. Also, another thing that is it, the question beyond is it for you? And in many cases, it may not be for you if you're not willing to take a risk, because it's a very risky proposition. The rewards are also great, but it's risky to set off on your own in counsel practice because once it's a financial risk. So unless you've worked for a couple of years and built some capital, it's very straining initially. And you never know whether your practice will lift off or it won't. So that is a risk that you need to be able to take. And many people are not that or many people are a little risk averse, which is completely okay, to each his own. So this is whether it is for you or not. For me personally, I wanted to experience the thrill of appearing in court. It was something which called me, it was something which really attracted me. And I wanted to do something on my own. I wanted to, really develop a practice which I can truly say is something that I've done completely on my own. Of course, everyone has mentors and assistants in the industry, but this is what I wanted to do, set off on my own. And therefore, I think it was a right decision that I had made and I have made. Now, coming to the next question, what kind of work do you do as a counsel? And the answer to this may surprise everyone because 90% of the work that you do as a counsel is reading. So you have to read, read, and read more. And then the argument portion is just the tip of the iceberg. Once you have percolated everything, once you know the facts inside out, once you've read the law, researched the law, then you only present that 10% of the rest that you've read, which you feel will help your case. So it's not like you uh, reproduce everything that you've read in your arguments. So reading is the first thing. And this is something that you don't charge for. Bear in mind that generally you don't charge a reading fee for reading your papers. But of course, you're more than well compensated when you charge for your appearances, etc. Then the second thing you do a lot is research. As I mentioned, you have to look up the law, you have to look up case law on various subjects, and this is also really important. So that is the second thing that you really need to do. The third thing that you do as a counsel is drafting. Now, especially as a junior counsel, a lot of your time will go in excuse me, in tedious drafting of pleadings, in drafting of written submissions, and these take a long time. In drafting of evidence affidavits with the uh, client present, the witness present. And this can be tedious, it can be painful. It takes up a lot more of your time than just appearing, and you can charge relatively less for that. But it builds your foundations. If you can figure out what you're thinking about, put pen to paper, and crystallize your thoughts, there's nothing like it. And therefore, drafting is very important as a skill. And initially, I keep saying this, you're dispensable, which means that you're a junior counsel, you're replaceable. It doesn't matter. For a law firm to hire you, they can hire another junior counsel as well. So if your drafting is good, they'll come again to you, again, again, again. And they'll keep coming back to you because they know that you have on point drafting. So that's a very important skill. And then lastly, of course, you have appearances in the High Court and in various fora like the NCLT, the City Civil Court, and if you're lucky, even the Supreme Court. But that's just the tip of the iceberg. After you've done all the hard work, which is 90% of the work, then the 10% is the tip of the iceberg when you actually get to charge for doing relatively not a lot. As a junior counsel, generally you will be appearing as a second brief, third brief, or something like that. And there are very few and far opportunities for you to appear as the first brief initially. So in the first couple of years, for me also, it was the case where I was, waiting for an opportunity, to appear on my own. And I would speak to seniors and they would say, you have to wait in line, you have to wait for your turn. And inevitably there'll be a situation where your senior is stuck in another court, or uh, he has an arbitration and he can't make it to court, and then they tell you that okay, you have to go on, and you get your break there. So it's very important to have patience, and these are the kinds of work that you initially do as a counsel. What is a typical day as a junior like? And this is what I'm describing is especially true for when you just start out counsel practice in the first year or two. And so I would like to mention that when I just started out counsel practice, I was extremely free. I didn't have that much work. And I was, in fact, I even taught for a couple of years at GLC on various subjects because I had the time and I had the bandwidth to do that. And today, if you ask me to do the same, it would be very difficult. But uh, typical day as a junior when you're just starting off is you get up in the morning. If you have matters in the day, you get up early in the morning, maybe 6 or 7, or you read late in the night, but I typically tend to get up early. And you read for those matters to refresh your memory, or if you're reading for the first time. You prepare your notes, you prepare your points, and this is between say 6:30 and 9 typically. And of course you have to get in your breakfast, your daily requirements. Then you go to chambers around 9, 9:30, and maybe you'll have a conference in the morning, or maybe you have to read more. So a conference is typically with the attorney or the advocate on record, who will refresh you on the points that they want you to argue, and the client will be there. And so this is what happens prior to court even beginning at 11 o'clock. Then between 11 to 2, you'll again have several matters, maybe a couple of matters, or maybe even one matter just when you're starting off. And or you may not have any matters also. That's also very possible. And you'll go to court. It may take time for your matter to be called out, etc. Then you'll come back to chamber, then you'll go again, and then this continues till 5 o'clock. And then after 5 o'clock, again you have more conferences, you have more meetings with clients. You have, sometimes you're the lead brief in the matter, so you'll be directly hosting the conference, or sometimes you'll be with a senior who will be leading the conference. And the most important thing that you can do as a junior, when you're a junior counsel, is be completely and thoroughly prepared for the conference, especially if there's a senior involved, especially if the advocate on record is going to be there, because then you can impress them. You can say that, look, I know the matter inside out. And that's what they're looking for, really. A senior counsel is looking to the junior to brief him on the most important points and to know the record inside out. If they can rely on you, they will recommend you for other matters as well. Now, this is what typically happens till about, say, 6, 7, 8. Then you also have drafting, which you do whenever you have some free time. So you'll be drafting. Sometimes it goes well into the night, and then again you have to get up the next day. There's a funny thing when you initially start counsel practice. You're completely free, and you think, okay, wow, this is the life. I have one matter in 3 days, and then I don't have anything to do. I can do whatever. I can get my hobbies going. I can do anything. And then when the work hits you, you have no time whatsoever. Even on weekends, you'll be working. Even on Sundays, you'll be working. And that's a good kind of busy. It's a good problem to have. So many people think that, oh, counsels don't have that much of a hectic life as compared to in a law firm. But that is, let me assure you, that if you're a decent counsel, that is not the case. And I'm sure you can be. So, and let me give you an example of getting up to read. So there was one matter in which I was briefed as the second brief. It was an arbitration, and I was brought in right at the fag end of the arbitration because my senior needed some assistance in preparing for the final arguments. I was thrown in the deep end because I knew nothing of the matter. So I think I didn't sleep for 5 days straight just trying to catch up on the reading in the matter, because there was volumes and volumes. It was a very high stakes arbitration, and ultimately we succeeded. But that's not the point. This is a typical scenario that you'll get, especially as a junior, where you'll be thrown in the deep end and expected to swim, and you have to do it. You have no choice. So that's typically a day in the life of a counsel. Now, most of you must be having questions on how do you get started? Like, where do you even start to become a counsel? And I would say starting is not once you graduate law school. Right now is the time to start thinking about what you want to do and to do internships. I would recommend you to do intern with counsel, with senior counsel, see what their work involves, get the basic foundation of how court functions, how judges function, um, and just follow around the senior in court and just get that basic foundation. Because unfortunately, our legal system, our education system does not permit that kind of practical experience which you would get interning with a counsel or with a judge. So I highly recommend that you do that as a student. The second thing is that once you have interned with a counsel, you know that you're interested in this kind of work. Then you, I highly recommend, and I would encourage everyone to not directly start off as an individual practitioner. And by that I mean, don't start off your own chamber once you graduate. It's very important, and I would suggest that you work in a firm for a couple of years. Now, this is not mandatory. I know many counsel who have started off directly into counsel practice, but for me, you get that grounding, that basis on how filing happens, how you have to deal with clients, how you have to prepare for a matter, etc., etc. If you work with a law firm in the litigation department, thereafter, even after that, if you want to start counsel practice, I would say join a chamber a of a well-known counsel. And see, what this does is all this foundation work you're doing, working in a law firm, etc., it makes you less raw, because once you step out as a counsel and you appear before a court, the court will expect you to have a certain basic knowledge of law and of procedure. And you'll not appear raw, you'll appear more refined, as if you know what you're talking about. When you join a counsel's chamber, the senior counsel will teach you that this is how you appear, this is what you need to say, this is what you should not say or avoid saying at all costs, etc., etc. So this is why you need to find a good chamber, a good senior who will take you under his wing. Now, how does it benefit a senior to take you under his wing? See, the senior is not paying you anything. Neither are you doing the senior's work, nor and you're occupying space in the senior's chamber. So it benefits the senior because he has someone to discuss matters with. If he has some research points, then you can do that for him. And it benefits you because you get to learn from the senior. You have other chamber colleagues to learn from. You can discuss your points, and most importantly, your senior will be the one giving you the work initially, because you sit in on conferences, you'll get that kind of work. So initially you'll get work through your senior, and that's how it will benefit you. Remember, you're not getting paid by your senior, you're not getting a salary. So it's a very, very risky proposition, and it takes some time to develop. Now, I think I'm going to discuss a little more on what kind of a senior you should, or what kind of a chamber you should join. And you should join a senior who has a good standing in court, and who doesn't have a reputation for having fast practice or sharp practice, who has enough matters so that you can work on them whether you get a brief or not, and who can spend time with you, hone your skills, give you some personal attention, rather than someone who is extremely busy or who has too many juniors already. So I would not encourage people to go to a chamber where there are already 10 or 15 juniors. So this is something you need to keep in mind. You need to join a chamber. And how would you apply? Most people will have this question: how do you apply to a chamber once you graduate, or once you're ready to join a chamber? I would say the best way to apply to a senior counsel to join the chamber is when you have worked with them previously. So either you interned with them and they're impressed with your work, or you've briefed them from a law firm and they know you, they know your work, they know what you're capable of. Because remember, there are limited seats in each chamber. This is something which is very, very important. Each chamber has maximum maybe 5 or 10 seats, and it's a rolling thing. Once a junior becomes a little more senior, he'll go and start his own chamber. So there are limited seats. No senior wants to get someone who they don't know is hardworking, is relatively intelligent or diligent, and who they can trust personally and professionally. So, ideally, I would highly recommend that you intern with the senior counsel that you want to join, or you apply to someone who you've briefed and who knows your work and who can rely on you and knows you that way inside out, because then you're more likely to get a spot in that chamber. Remember, it is very, very difficult, and I'm speaking about it very casually, but it's very difficult to get a spot in a good chamber. So this is the most important aspect about how to start as a counsel. All right, now I'm just going to speak a little bit about how do you get work, how do you really develop your practice. So as a junior counsel, typically you will be sitting in on conferences where your senior is briefed in a matter, even if you're not personally briefed. And you'll be giving your two bits, you'll be researching, you'll be contributing to that conference. And then if there's a requirement for a junior counsel, since you already know about the matter, the advocate on record will point to you and say, look, he's already here in the matter, and let him assist his senior in the matter or another senior in the matter, because he's put in the effort, he already knows the matter. Secondly, if you impress your senior may even recommend putting you in on a matter if he requires assistance. Other juniors who are your contemporaries or who are slightly senior to you, or your chamber colleagues even, will recommend you to be taken in on matters where they can't personally appear. The golden rule about being a junior counsel, I would say, is never say no to a brief initially, because you should show that you are hungry and that you want to do new matters, and that you really want to be a counselor. So one anecdote I can give you about how I initially got a few briefs. The first brief that I got was I used to go for every single conference of my senior. And even if it was at 8 o'clock in the morning, I used to show up in the chamber. And so I was the only person there, only junior there. So there was this one matter which was a very large litigation involving uh, area in Bombay which was worth 11,000 crores. Imagine some large acres and acres of land in the island city. And I was the only person. I would be show up at any time there was a conference. I would show up, and eventually the solicitor noted that this junior is showing up for every matter. He's paying attention. He's looking at the brief, and so why don't we brief him in the matter to assist Mustafa, who's my senior. So that's how I got my first brief. And then slowly, once you follow your senior around, once you give him some good points, some good notes. For example, in another matter, I had written down the points that he should, that I thought were important, and I just left it in his brief. And he happened to look at it and he said, "Who has made these notings?" So that's the kind of way you develop your practice. Then word of mouth, once one advocate will see that he's done a good job, he'll recommend your name to other people, to other clients, to other advocates as well. And then once they see you in court appearing, your word of mouth increases and your face value increases. So that's how you get work. I know it's very daunting to think that you have to get your own work as a counsel, but that's a risk that you have to take initially, and it really pays off to be a counsel. If you deliver timely work, if you work hard, if you genuinely deliver diligent work, there's no way that someone will come to you and say, look, we're not going to hire him. Because they will, if they notice that you are working hard, you're working diligently. The most important thing that you can do as a junior is to never engage in sharp practice, never be sly, never find shortcuts. The point is that if you do shortcuts when you appear in court, if you try to act smart, try to act sly, your reputation gets tarnished. And your reputation in the eyes of the judge is the most important thing that you can have. So, therefore, this is something which is very important as a junior counsel, and this is how you build your practice, build your work. Now, another important thing is to build mentors in the profession. So, uh, if you start off as a junior counsel, you should build mentors, speak to people, ask them how they did it. Like we're having a discussion right now. So, speak to them, try to get as much information from people as possible. And learn from them, learn from people the good things, what to avoid, etc., etc. That's how you get started as a junior in counsel practice. Now, the last thing I want to talk to you, and then I'll go to questions because I think I've exceeded or gone ahead of my estimation of how long I would take. What are the challenges in counsel practice and what are the rewards or the advantages? So, first, we'll go to the challenges. The first challenge is that, of course, you struggle for many years. It's not like the first time you join a chamber and say, I'm going to be a counsel. It's not like you're going to get a lot of work. It's not like you're going to get matters. You have to be very, very, very patient, and it will take time for you to build your practice. The second thing is that it's a high risk game because sometimes your luck is bad. You may not get briefs from weeks on end, months on end, even, and you may think that this is not worth it. For example, if I had joined counsel practice, say in January of this year, and the pandemic struck in March, I would really be struggling right now with zero matters, zero work, even though courts are starting virtually. But no one knows you. Why will they brief you? You're interchangeable, you're replaceable. So why will they brief you in particular? So I would be really struggling right now and have no work whatsoever. So it's a high risk game, and that's a disadvantage if you don't have appetite for the risk. Then initially it's not financially lucrative in the sense that uh, colleagues in law firms will be earning much more than you initially, only initially, but that's something that you have to keep in mind. Your peers will be progressing faster than you. It's it's dependent on blind luck, which is another disadvantage, because sometimes you can do all the work and then the matter doesn't progress, you don't get your pay, etc., etc. You have to initially work very, very hard, and you are replaceable as a junior. So if you do the work tomorrow, they'll go to someone else. So it's a zero sum game in a sense, but believe me, it's worth it. And the other disadvantages are it's very frustrating. You have to wait around, and you have to be patient for your day in the sun. But believe me, when you get busy, you will really get busy and you'll have a lot of work once that time kicks in. So wait for it. Uh, Another disadvantage, I don't know if it's a disadvantage, but you have to read a lot, you have to do a lot of hard work, you have to prepare a lot, and most of that is not seen, it's not visible, but you do have to do that. And if you make a mistake, this is a big disadvantage. If you make a mistake in court, it's a very public mistake because there are 100 other people watching you. So everyone is bound to make mistakes. Everyone. I've made innumerable mistakes in my 5 years as a counsel, and so has everyone. In fact, the best advice that I got from a senior counsel, one of my mentors, who I spoke to while I was getting into it, he told me, Anirudh, look, you're bound to make mistakes. I made a ton of mistakes, but whenever you make a mistake, don't think about it too much. Learn from it, but don't overthink it. And it should be like water off a duck's back. Move on, and constantly move on. I've made such embarrassing gaffes in court. I've been rightly yelled at by judges for making a submission which I ought not to have made. And still, you think about it for one day, you feel extremely bad about it because there are 100 people watching, but then you move on the next day, and then something good happens. So it's a it's something that you need to remember. So these are the disadvantages of counsel practice. Now let me talk about the advantages and what uh, and it is a big advantage to be a counsel according to me. The first is that if you work hard and sincerely, and if you're reasonably good at your work, I don't believe that as a counsel you need to be brilliant at, at law, but you need to work very hard, and you need to be sincere at your work. Then you are bound to do well. Of course, there's a bit of luck involved, but luck is only can only play a small part. If you're consistently doing good work, if you're showing that you're good, there's no reason why advocates or law firms won't come to you to brief you in matters. So you can definitely succeed in counsel practice if you work hard. There's a high risk, but there's also a high reward. And the reward is that your reputation is built in counsel practice. You're known as an individual rather than as a partner of a law firm. So they respect you as an individual lawyer for your knowledge, for your skills, and for your ability in a courtroom. Your face value increases with time and you get recognized, and that's a great advantage. Of course, it may not, everyone doesn't like that kind of publicity or doesn't need that kind of publicity, but that is one of the advantages. And the community, the legal community, once they see that you're committed to doing what you're doing, they accept you as one of their own. So that is a big advantage according to me. Another advantage is that you're engaged in stimulating, challenging activity. It stimulates your brain, it's intellectual pursuit, because uh, building an argument, there are various nuances which you will only learn as you progress. Like, for example, when I just started counsel practice, I would think of a problem in a particular way. When I spoke with seniors and others, it developed into a completely different way of thinking or way of approaching a problem. So your mind will expand, you will grow as you stay in counsel practice. Then of course you can do matters close to your heart. For example, for me, I was very much into environmental law. I was very much into public law and PILs, etc. And I've done a number of matters pro bono as well as paid in environmental law. I've even represented clients in Goa or even in the Supreme Court in matters involving large uh, involving effects on the public, and it's been really rewarding. You get to actually work on matters which you're interested in. Recently we were doing a matter on the metro railway and how the planning has been completely haphazard and it's a big risk to the environment. So these are the kind of things that you get to do as a counsel, if and you can't do that as part of a firm necessarily. There are flexible timings, which is another advantage, and flexible timings, but not that you work less. You work the same amount of time, and ultimately you're the master of your fate. You're the captain of your ship, so you will progress only as much as you work hard. Uh, you will only do as well as you want to do. So this is really the biggest advantage of being a counsel, because you get to guide your own fate and you get to really make an impact when it comes to appearing in court. So for me personally, it's a very thrilling proposition to appear in court, to do these kind of matters. It's not for everyone if if you don't enjoy that, but for me it's very exciting. And This is what I consider the main key advantages of being a counselor. Now, I have some memorable cases that I can discuss with you, but I'd rather take up some questions. So, uh, Aditya, can you read out some questions or ask people to uh, I mean, you can put on your videos and ask me questions as well.
So if everyone can just type in their questions in the chat box, or if they could enable their videos and ask Sir questions themselves, this would be the time. Shraddha asks, how did pursuing solicitors help you in your counsel practice?
So I wouldn't say that it directly helped me only in counsel practice. I think it helped me overall become a better lawyer because it's a very rigorous exam and you really learn a variety of subjects. So once you have read all those subjects, you feel like you can tackle any problem or answer any question, at least uh, initially, or maybe you have read about it somewhere, so you have the confidence to know that you can look up the answer and give a correct answer. So it's a great confidence building exercise, even if you just study for the exam and don't even give it or don't clear the exam. So I think it's very important, especially in Bombay, to try giving it, but it's not a compulsory thing, and I really enjoyed giving that exam. Yeah.
Sir, I have a question. So, when you receive a brief, what is your mental model to approach the problem?
So that's a good question. What happens is typically you get a brief, you will read it threadbare. Almost as soon as you get it, you'll read it threadbare. And you have to identify the key issues which are against your client and the benefits of the case. Once you've read the matter threadbare and you've identified these issues, then you have to really look at the law. And by looking at the law, I mean going on SSC or Manupatra, getting the research done so that you can assist your senior when you have a conference. Or if you're appearing individually, like you do in smaller matters, then you know what you need to argue. You know the law, and that's about it. Then you have to really make your points and argue the matter. Yeah. So I think,
Sir, we have a lot of questions on the chat box. I can read every single one out to you.
sure, sure.
Avdut Patil asks, what do you suggest to a new graduate with no internship experience initially for pursuing counsel practice?
New graduate with no experience for pursuing counsel practice, then what I would recommend is first, uh, you have two options. You can either work in a law firm for a few years and do litigation and see from the other side what a counsel does, because you get a perspective from that angle as well. And when you brief counsel, then you'll get to know them, get to know people in the industry, and see whether it's for you. That's the first option. The second option is, of course, to I mean, even though you've graduated, I would still recommend doing an internship with the council if possible, because they are unlikely to take you in without seeing your work. So if you intern with them and it's a temporary thing, and they see that you have the capacity to work hard and have a inclination to do council practice, they're likely to take you in as a junior. So that's what you should do.
Okay. Um, the next question is, what is the nature of the relationship between a junior counsel and a chamber senior on the original side?
So the relationship is like a mentor and a mentee essentially. Uh, Having said that, I mean, if my senior asks me to do a small research and I'm not briefed in the matter, I will still do it because it benefits him, benefits me to know the law, etc. Also, but I'm not his employee, and I'm still an independent counsel. He is not my boss. He is my senior, and I will always respect him as a senior, because what we have to understand on the original side is that once you're a junior of a particular senior, even when you move out and start your own chamber, you're always his junior, because he's taught you how to practice the, as a counsel. So it's more of a apprenticeship kind of relationship rather than a boss and a junior. You're learning the ropes of how to be a counsel under him.
Devashi asks, in your journey till now, what importance does your LLM stint at Cornell have? And how's the atmosphere at such an impeccable institution?
So let me put it two ways. I think my LLM experience was really amazing, and it was a mind opening experience, a life experience rather. But I would not say it's essential to for counsel practice. And the reason I say this is because you're not going there to learn procedure, you're not going there to learn Indian law. What you're going to do your LLM in is basic concepts of law which make you think like a lawyer, which make you think in a particular way which is beneficial to you as a lawyer. But having said that, does that mean that you need an LLM to practice as a counsel? I would say absolutely you don't need an LLM. But if you can get an LLM, if you have an opportunity to get an LLM, it expands your mind. You meet people from different backgrounds. You think of problems in different ways, and definitely all that experience will come into your experience as practicing as a counsel. So it's not like it goes to waste, but I would not say it's essential to practicing as a counsel. In fact, initially I had thought after doing my LLM that I may practice in the US, and that's what mainly I would recommend you do your LLM for. Of course, you can do it and come back as well. But if you want to make the most out of your LLM, then it's a gateway into practicing in the US itself or wherever you do your LLM from. Because law firms out there will recruit either their local uh, equivalent to LLB, which is a JD, or they'll recruit after that an LLM. So you can get a gateway to entering into that legal market.
Uh, so the next question is, what is the distinction between original side counsel and appellate side counsel?
There's no distinction really. I mean, as I mentioned before, technically there's no distinction between a counsel, a solicitor, etc. We're all advocates under the Advocates Act of 1961. Moreover, we are appellate side and original side. Technically, there's no distinction, but on the appellate side, many times I've noticed that the practice is that the appellate side counsel will also file his own wakalatnama, or his junior or someone will file the wakalatnama, which is something we don't do as a matter of practice on the original side. Also, as a junior on the appellate side, many times you are paid by your senior. Maybe it's only a stipend or a small amount, maybe 20,000 rupees per month or something like that. But many times you are in fact paid. And by appellate side, I include the criminal counsel in that category, because criminal law in the High Court is always appellate side law. So therefore, criminal counsel also follow this practice of generally paying their juniors a small amount, and then they can get over and above that whatever they get from the individual briefs. So that I would say is the main distinction.
So the next question is, how do you overcome a language barrier in litigation?
That's a good question, and I mean, there's no easy answer for that. You have to just work hard. Unfortunately or fortunately, depending on which perspective you look at it, uh, the higher courts in India are in English, and of course, district courts and other courts sometimes they accept Marathi or Hindi or whichever is the vernacular language. So I just think that you need to work at it relentlessly and make a conscious effort to improve your language, your English, by taking classes, by doing whatever means possible, by practicing the language. And that's the only way you will improve.
So the next question is, why can one not intern once they graduate?
Definitely, you can intern once you graduate. The only reason that you yourself may not want to is because if you see your counterparts or your peers at the same level as you, they are working and earning money. Whereas when you intern, generally, especially as a with a council, they are unlikely to pay you much or pay you at all. In fact, most of the time you're just going to be following them around, and they'll give you some small research work, but it's not like you're doing any actual work. So they're unlikely to pay you. So that's the only difference. Generally, you would want to intern while you're a student and not once you've graduated.
What do you suggest for someone who is, after working 5 to 6 years as a counsel, later realizes that it's not working for him?
I mean, I've seen it happen many times, and uh, there's no shame in going back to a law firm or going, because see, counsel practice is also a matter of luck. It's also a matter of getting briefs, and sometimes you have bad luck. It doesn't mean you're a bad lawyer. So I would say that you give it a good shot, maybe a few years, and then go back to working in a law firm or working as an advocate on record, and there's no harm in that. Or you go into get a corporate job or do anything else. If it's not working for you, there's no point in continuing down a path which isn't working. I mean, your ego only can get you so far. There's nothing embarrassing about switching your career path at certain point. So that's what I would suggest. And I know people who are very successful after having switched from being counsel to working in law firms or working as legal counsel in a company. So there's no harm in that.
The
Sorry.
next question is, if one is working with a corporate law firm and wants to shift to litigation and particularly counsel practice in the long run, what would be the way to start off? Given that there is no litigation internship experience.
So I think I've answered this question. If you're working in corporate law, then you need to first get a grounding in litigation, learn the procedures, etc., etc. So if you can't get a job immediately in litigation, then I would suggest maybe you can do an internship with a law firm or an internship with a counsel and really learn the basics before you dive in headfirst into counsel practice. And again, I emphasize that there's no harm in joining a counsel and joining a senior, so that you learn the ropes before you uh, dive into because many people want to ask me this question that why can't I practice as a counsel individually, why do I need to be part of a chamber? And according to me, you can only benefit from someone who has more experience than you. So that's how you get into it. Get some experience, get some base experience, and then dive into counsel practice.
So the next question is, how can one develop good drafting skills?
Oh, that's another topic for another day. I mean, it's very in depth, but the simple answer to that is practice. I mean, uh, initially when I would draft a plaint, for example, it would take me a day, 2 days, and it would be a very excruciating process. And then the final result wouldn't be that good. In fact, if I showed it to a senior, I'd get red marks all over it. And there's no harm in that. You learn from experience, you learn from practice, and that's the only way to learn. I mean, over time, you get better and better at it. Yeah.
The next question is that if the pandemic situation continues, what can be done career wise to tackle such a situation?
So is this specific to, I'll assume this is specific to counsel practice. And, it's very difficult right now for many people to, because there's not that much work, there's no work going around. And to practice as a counsel when there's no work is very difficult. You don't have a salary, you don't have something coming in regularly. So I think it's a very relevant question, but according to me, if you can hang on and uh, go through the rigors of it and then come out uh, on the other end, then nothing like it. if you can have the patience to, wait for the thing to improve, the situation to improve, then nothing like it. But if that's not your situation, then I would recommend that you at least take up a job or look for a job in the meantime, because it is very daunting, it's very difficult financially to many people, and it's completely understandable. So it's not something that you should feel ashamed about. uh,
Next
so
question will be,
how many questions do we
I'm
have?
sorry, we have a couple of other questions.
Okay,
We can take a last few.
maybe four questions we can take.
Okay, sir. The next question is, what should be a good balance between internships and academics?
Balance between internships and academics, I think both go hand in hand. Frankly, to be honest, at least when I was in GLC and giving the government exams, Mumbai University exams aren't that difficult to clear. I mean, uh, frankly, you just need a few weeks of study and practice to get through the exams and do well even. Maybe a month or two. But in the meantime, I think it's very, very important to intern and get that practical experience, because that really changes you and opens up your mind. You know what life as a lawyer will be like, and you also develop your interests and likes and what you like, your preferences, what kind of law you like. It improves you as a person. So, and you meet so many people, you develop your contacts. So I definitely think interning is very important.
Uh, the next question is, how was your experience of doing LLM in the US and then coming back to practice in India?
So, as I mentioned, I really loved my experience of doing my LLM, especially at a law school like Cornell. They teach you the Socratic method, uh, in the sense that they ask you questions and you have to come to the answer yourself. So it was something very different for me, very interesting, and I made friends for life out there. Um, but I think inside I always knew that I wanted to come back, even though I had initially thought that I'd work there. I always wanted to come back. So I knew what to expect. And again, I had worked for a considerable amount of time as an intern in India. So I knew what the work was. And that's when I come back. So it was for me, I was ready to come back. Yeah. So you
Okay.
can.
So we have the last two questions. The first question is, what are the hurdles that you face as a new counsel who is working towards being a successful one?
So as I mentioned, I mean, I think I gave you some challenges, and those are all challenges that I have faced, by the way. You have to struggle for a few years. Uh, Initially, you won't be earning much. If you're dependent on luck, you're dependent on your senior. It's risky, as I mentioned. So I've gone through all of that, and those are all the hurdles and struggles that you go through. And you have to also deal with your own self doubt. Like, if you mess up a matter, then you shouldn't immediately say, look, counsel practice is not for me. Or if you don't get work for a month, you shouldn't say that, look, I'm not getting any work, maybe this isn't for me. You have to have the patience to wait it out. And these are the kind of hurdles that you will definitely face as a junior counsel, because again, it's not like someone is going to come to you directly unless they've heard of you before, they know your work, etc. So these are the main hurdles that you do face on a regular basis. And as I mentioned, your mistakes that you make are very public. So people will see that, look, he's making a mistake. And you have to have that, spine to take the humiliation and say, it doesn't matter, I'll move on, tomorrow's a new day, So these are the kind of hurdles that you have.
So the last question for today is, as a counsel, do we need to have a knowledge of every area of law or be specialized in a certain field?
So, for example, I practice mainly civil and commercial law. And what that means is that I don't really practice any criminal law unless there's some specific small question which a client wants an opinion on or advice on. But I think you have to specialize, and it's becoming even more and more specialized as we go on, because now we have specialist arbitration counsel, you have specialist counsel who only do constitutional law, you have counsel who do uh, only pro bono matters, for example. So these are the kind of things which you need to focus. But initially, I would say when you just start off, you have to decide between whether you want to do criminal law or civil law, and then don't say no to matters once you made that decision. You stick to your all matters that come in of civil law. You try to do everything so that you learn new laws. And this is one big advantage of counsel practice. Every day is a new problem. You're problem solving constantly. It's very intellectual. You're learning new things as you go along. So I would not say you should restrict yourself initially when you start off. Maybe 5, 10 years into your career as a lawyer, you can specialize in some kind of uh, law. But initially, don't specialize, except, like criminal law and civil law. You have to decide on one of them, because I don't think it's very practical to do both. So shall we take one more question, or are we done? We're done,
So we
right?
are done.
Okay, perfect.
So we have one last question which just came right now. Would you advise counsel practice for someone who wants to be a judge during the later part of their career?
That is a very good question. And in fact, the most common way to become a judge is through the bar, because what happens is that especially in the High Court, you get approached by the judges if you're doing fairly well as a counsel. Then judges will approach you and request you that, do you want to join the bench? And you'll get invitations to join the bench. So that's the most common way to become a judge, especially in the higher judiciary, that's the High Court. The other common way is to give the judicial services exam and all of that. But I mean, I would highly recommend it. If you want to do become a judge, then do counsel practice. You have to build a standing as a counsel, and then people will approach you to become a judge. So definitely, the two objects of doing counsel practice is to become appointed as a senior counsel or to become a judge. This is generally what people want. Yeah. So thank you everyone, and thank you Sachi and Anushka and Aditya for helping out, inviting me. It was really a pleasure to talk to all of you.
I would like to express my very sincere thanks to Mr. Hariani, not only for this insightful lecture, but also for keeping all channels of communication open and being one text or call away, which made the organizing process very streamlined. Also, this could not have been possible without our professor in charge, Masani ma'am, and conveners and our seniors' support. Also, a very big thank you for my junior core for staying in touch, being prompt, and helping me out. And a final thank you to everyone who attended for being a patient and interactive audience. Thank you so much.
Thank you.